Welcome to week 8 of our regulatory compliance course. This is the last week of school, y'all. We're going to be talking about inspections and enforcement today. But before we get into that, I think I need to tell you that last week's session on advertising and promotion and labeling, and this week's session on inspections and enforcement are probably the two most important times that you and I are going to spend together since we began this course nearly 8 weeks ago. The reason for that is the possibilities of making errors in advertising are so enormous and so easy to do that it really requires our concentrated attention. And I want to spend some time this hour talking about inspections. I know we covered it early in the semester. I want to touch on some additional points, and then I want to get into both civil and criminal enforcement. Then I've got a couple of parting words, and then we'll get right into it. So let's take a look at inspections and enforcement. And the thing to remember about inspections is that's the primary method that the FDA uses in identifying regulatory violations. There's where it learns about, on its part, industry trends, and it spots manufacturing or testing problems, and also shares information with the facilities they are inspecting on how they believe our organizations need to behave under the regulations. And inspections, as you know, are prominently used in almost every warning letter and certainly in injunction proceedings. So with that overview, let's take a look at inspections a little bit, and they're generally for-cause inspections. And notice here where the problems come from. A complaint for an employee or a former employee. As you may know, there are procedures in the federal and state laws now called whistleblower or qui tam. I'm going to talk about that later in the time together, where individuals can sue on behalf of the government, and they can do that privately, and if they win, they share in the recovery. So your most prominent opponent for the future is probably either working for you or just got fired, or is that person that got passed over for a promotion or got transferred against their will, or has got some bad feelings towards your organization, or maybe an inspection is provoked by a recall or some complaints from customers or competitors. But most inspections are for cause, or a substantial amount of them are. Some of them are regular, but so many others are for cause. And what we want to do is avoid a 483 and a warning letter if we can. And while the inspector is there, go ahead and make minor corrections. And that shows your commitment to compliance. And maybe you can escape a scathing 483 or a blistering warning letter. If something's really wrong, you're going to get a 483, and that's going to have observations. These are less than finding, but they're observations, and probably a warning letter. And who knows, that inspection may provoke a seizure action, or maybe even an injunction proceeding. And if you're an import firm, you can expect an import alert, or maybe even detention of products without a physical exam. The FDA's got broad inspection and access authority, and I've put some of those dimensions on this slide showing equipment, materials, containers, and labeling within reasonable limits in both finished and unfinished goods. And I put the FDC section and subsection in the last bullet point for your information. One of the things we don't want to be doing is refusing access to the FDA when they show up. That can provoke civil and criminal sanctions. Things that can get us in trouble are refusing to permit access to or copying of certain records, refusing to let FDA enter and inspect, failing to maintain certain records or make certain reports to the agency. And because of all of this, and I'm going to talk more about this later, the FDA has issued a guidance on refusal to permit access, and I've included that as a required reading in Blackboard for this week. Except for biologic product manufacturers, there are no specific legal authority, either in the statute or rules, to interview company employees. Therefore, you need to have a company policy with respect to interviews. And I hope one of those policies and procedures is to require interviews in the presence of company counsel. I said before that FDA has broad authority to inspect facilities, and it differs with respect to specific facilities. We don't have the time or the ability in this shortened course to go through each of these aspects, but I've put each of them on this slide so you will understand, and you need to follow up if you're associated with one of these kinds of entities, to understand the specific authority that the FDA has to be in your facility and what it's entitled to look at. Here's the slide I was referring to a moment ago about refusal or delay. I've subtitled it gamesmanship because this is one of the fastest ways that I know how for you and your organization to get in trouble with the FDA. Folks, these inspectors are not fooling around. They know what they're doing, and they can sense delay or refusals or obstruction very, very quickly. They can sniff it out. The FDA statute makes it a criminal to delay, deny, or limit an inspection. And what may happen if you provoke a delay and have drugs in the shop, they may be deemed adulterated, and then you've got larger problems. And here's a reference to the guidance that's in your Blackboard materials, and I commend it to your careful study. And recognize that refusal to permit a photograph or photographs by the inspector is likely to be a refusal or limitation of the inspection absent a reasonable explanation. For example, the popping of a flash bulb or the flash camera may interfere with some of the lab work that you're doing, but be cautious about refusing to permit photographs. You need to prepare for inspections, and one of the first things you need to do is make sure that every outstanding deficiency or observation from the last inspection has been taken care of. Folks, one of the things that the inspectors is going to do, probably before they arrive, is check into the last inspection and see what the problems were. And that will probably be the entree to this inspection. And what we want to do is avoid repeat observations, because that's going to raise eyebrows. They're going to, you need to address any outstanding customer or user complaints, the status of corrective or preventive actions, and in your preparation, your long-term preparation, You want to stay apprised of all recent developments in FDA law and regulatory policy. There are ever so many excellent websites, including your industry website, that can help you do that. And you need to know that if you're relying on out-of-date FDA policies, that alone can be the cause of a negative inspectional observation, and that's not something we want to have happen. In terms of policies involved with inspections, you want to have a standard operating procedure for those inspections, and it needs to be detailed. And when that procedure is prepared, train your employees, and then train them again, train them again, train them again, train them again. You can't train too often because people will forget, they'll be distracted, they'll start paying attention to their work instead of this important part of preparing for inspections. You want to prepare your personnel, train them. You want to make sure that certain people, and I've listed just a few as an example here, know their roles in that inspection. The last thing we want to have happen is have our people ad lib who's responsible for what. So fork those out among the directors of regulatory affairs, quality assurance, and production. And you ought to have your general counsel there also, and somebody from the front office there at the inspection also, and designate one individual as the primary point of contact for inspections. Because we know that inspections are inevitable, practice, practice, practice. Formal training on the company's policies is vital. I recommend at least 1 or 2 mock inspections annually. And if I were responsible for compliance, I would demand that my company conduct a formal risk analysis so I could learn what our tender spots are and try to fix those before the next inspection, so that if a problem arises during that inspection, I'd be able to tell the inspector, we conducted a formal risk analysis, we identified that as a problem issue, and we're working on it as we speak. That ought to bring a grin to that inspector's face, because that's music to their ears. You need to have in that policy how you're going to deal with questions and answers. At a minimum, at the end of each day, have a closeout meeting. Be prepared to answer questions proposed by the inspector. Keep a log of those questions and the answers. Document the questions and answers, what was reviewed, what samples were taken, etc. And do a daily summary of each day's inspections and get that in the hands of the people who need to know. There's going to be a closeout meeting with the inspector where violations will be discussed and maybe corrective actions. And if there aren't any significant violations, a 483 will detail observations. Now, if things don't go well, you're going to be set up for civil enforcement, and we're segueing into a different area, and that's called enforcement. And I want to talk about the civil area first. You've got several important resources, and I've put these in Blackboard. Chapter 6 of the Regulatory Procedures Manual, the FDA's compliance guides, the FDA's compliance policy guides, and I want to spend a moment just mentioning to you, because we're not going to go through it, it's 500 pages long, for goodness sake, the Connecticut federal price fixing lawsuit that was filed May 10 of 2019. I asked you to take a look at the allegations because I wanted you to see how many of them involved advertising and many of the topics that we have studied in this course. If you have a moment, I want you to look at the prayer for relief in the index, and I want you to notice that it's misspelled, and ask whether or not you think that misspelling or typographical error demeans from the quality of the complaint. So one of the things under civil enforcement that the FDA can do is seizure, where they can seize and condemn the products. They will want to get that product off the market quickly, and the rationale is protecting public health. These proceedings are called in rem because they are not against a person, they're against a thing. So in rem proceedings are against the product itself, and that will be the in rem proceeding that authorizes the seizure. And in a seizure, some of the results are destruction, reconditioning, or conversion of the product. Seizures are rarely initiated without notice, but notice is not always required. A big brother of seizure is injunctions, but unlike injunctions, unlike seizures, injunctions operate against a company or individuals, and they're called in personam proceedings, P-E-R-S-O-N-A-M. And if there's an injunction, the company must stop manufacturing until the injunction is lifted or FDA is satisfied and dismisses the case. You need to know that individuals can be held personally responsible, and I'll talk a little bit about that later. And if you fail to comply with the injunction, you're going to be looking at contempt proceedings, which are often more harsh than the injunction itself. And I've included a citation for you in the last bullet. Escalating now in terms of seriousness, we now come to TROs, or temporary restraining orders. And a TRO is usually done to put things on hold to get temporary relief before there's a hearing on a preliminary injunction. Now a TRO can't exceed 2 weeks unless it's extended for good cause or with consent. Now a TRO can be issued without notice, but because of the ex parte, EX space, PARTE proceedings, the courts will expedite a hearing for the preliminary injunction. And the test is whether that TRO should be issued because the violation is so serious that it must be controlled immediately. The FDA doesn't have to show harm, because if it alleges that there's a violation of the act, harm is presumed. Our almost final stop is a preliminary injunction. This is to restrict the conduct until the case is settled or a permanent injunction is issued after a trial or further briefing. And unlike a TRO, a preliminary injunction cannot be issued without notice, and it's usually subject to a court hearing, and the injunction is based on the evidence presented. Now, if we don't deal with the preliminary injunction and get it dissolved, it'll stand indefinitely or until somebody pays attention to it. And a preliminary injunction, if it's not dismissed, will eventually become a permanent injunction, and that will restrain the company's conduct until the injunction is dissolved. Usually, in injunction cases, there's a consent decree that's entered, and that's the most common path. There's a couple of defenses. Voluntarily discontinued the practice is a good one. Another one is a genuine good faith effort to comply, the good college try theory. And you need to know that injunctive relief is viewed by the courts as being used only sparingly to prevent future harm and not to punish for past violations. One of the final things I want to tell you about civil enforcement are equitable remedies. Now, equitable remedies are not legal remedies. Legal remedies have to follow the law. Equitable remedies do what's fair. That's why it's named equity. They're equitable remedies. Two of the equitable remedies are restitution and disgorgement. Restitution is where any benefit obtained by the wrongdoer is recovered. Disgorgement is if the wrongdoer made any profits, the wrongdoer is to disgorge those profits to prevent being unjustly and unfairly enriched and to deprive the wrongdoer of so-called ill-gotten gains. Now there's an open hot question in my legal community about whether or not FDA has disgorgement or restitution authority, but know that it's out there and you really don't want to be on the wrong end of an equitable remedy case. Let's move into criminal enforcement. You can violate the FDA even without any showing of intent. And if that happens, it's a misdemeanor, and you'd be facing a year of prison or a fine or both. Now, violation of FDA regulations can be a basis for criminal penalties, but only if Congress delegates authority to the FDA to create regulations with criminal effect. And now, you need to know that the federal circuits are divided on this issue, but why don't you take it as a given that if that policy changes, it probably won't be in favor of the industry. So just don't violate any FDA regulations. And there's an internal memo within FDA that it won't bring cases solely on violation of its guidance documents. So don't bet too much on that, but at least there's some argument if it happens. Several kinds of violations involve strict liability. That means if it happens, you're guilty. And those are listed in section 303A1, and they're misdemeanors. Again, they lack any intent, and there's a strict criminal misdemeanor liability standard in section 303. To establish a misdemeanor, FDA would have to prove that there was a distribution in connection with interstate commerce and the food or drug was adulterated or misbranded. I told you before that corporate officers are responsible, and here's some additional information about that. It's in 303A1 where you see a strict liability standard. And I want to talk with you about the Park Doctrine, and that holds that responsible corporate officers may be prosecuted for actions of their companies even though those officers did not personally engage in the unlawful activities. That's the Park Doctrine, and it applies even if the corporate official was unaware of the violation, if the official was in a position of authority to prevent or correct the violation and did not do so. So we want to be careful, especially if we're in the front office, that we take care of what's going on in the back shops. There's a couple of defenses. One of them is impossibility, and this is raised in Park, that says a defense is that the event in its criminal aspect does not require that which is objectively impossible. So to prove that, we must introduce evidence that we exercised extraordinary care, but was nevertheless unable to prevent violations. Felony violations are in 303A2, and usually you'll see those happen when a second offense under the Act occurs, or the defendant committed a 301 violation with intent to defraud or mislead. Other criminal violations include certain violations of PDMA that can result in imprisonment of more than 10 years or a fine of more than $250,000 or both. And 303E provides for felony offenses related to distribution of human growth hormones if it's done unlawfully. Criminal penalties in the Act include for 301 misdemeanors, imprisonment for up to a year per violation plus fines. Felony violations up to 3 years per violation plus fines. Other violations allow maximum terms of 5, 10, and 20 years plus fines. Here is more information on fines. They begin at $100,000 and go up to $1 million, and you can see the different factors in this fines slide. There's an alternative fine provision in the federal code, and I put the site in this slide, that where there's a gain involved and another person experiences a loss. If the gain is large enough, the fine can be not more than the greater of twice the gain or twice the loss. So it's just an alternative fine provision. There's a statute of limitation in these matters, and it's 5 years after the offense, and I put the statute up here for you. A statute of limitation is a law that says after a date certain, unless there is good cause, there is a date beyond which a lawsuit cannot be filed. And if it's filed and not excused or they're permissibly extended, it'll be dismissed. So there are statutes of limitation. The one for FDA work is in the first bullet point. I've talked about the legal basis for FDA violations, and I want to now briefly summarize for you the remaining arrows in the FDA quiver, and there are at least 7 of them. The first arrow is mail fraud, and I put the site up there for you. That act prohibits devising a scheme to defraud or causing the mail to be used in order to execute the scheme. So we don't want to be involved with alternative 1 or alternative 2, wire fraud. Wire, radio, TV, in interstate or foreign commerce to execute a scheme. Alternative 3 is a criminal conspiracy. We've got to have 2 or more who conspire to commit a federal offense. Alternative 4 is RICO, the Racketeer Influenced and Corrupt Organizations Act. That's where we have organized racketeering that gains funds, and they use those funds acquired from those activities. So that's another alternative. A 5th alternative is healthcare fraud. It is unlawful for a scheme to defraud a healthcare benefit program, read Medicare, Medicaid, or obtain under false premises any benefit from a healthcare benefit program. Alternative 6 is a little bit more complicated, but it talks about false statements. And to be a false statement involves a lot of knowingly and willfully. For example, falsifying or concealing a material fact by a scheme, making a false or fraudulent statement or representation, or making and using a false writing or document that contains a materially false statement. In addition to all of those, know that it's criminally actionable to knowingly make a false statement to the FDA, and I put the site there for you. And the last arrow in this series of 7 arrows is the obstruction of agency proceedings, which is a favorite topic in the news these days. But we don't want to get involved in conduct that's threatening or corrupt that obstructs or impedes the law in a pending agency proceeding. Now, why did I go through all of these alternatives, and why are the federal prosecutors so interested? Well, there's some very good reasons, and I've listed 4 of them. The prison terms are longer, they're easier and simpler to prosecute, the jury instructions are pieces of cake, and they sometimes have longer statutes of limitations. So know those alternatives, keep them in mind very well, because they're a prosecutor's favorite. I mentioned whistleblower proceedings a moment ago, and that's in the law known as qui tam, he who sues on behalf of the king. Qui tam involves not only its case, but in some instances parallel proceedings. And in qui tam, a private citizen sues on behalf of the government and can share in recovery, and they often give rise to parallel criminal proceedings. And recently, qui tam actions instigated numerous criminal proceedings regarding what? Well, off-label promotion of drugs and devices. And then the last thing I'd like to talk with you a bit before we sign off are sentencing guidelines. And what a dreary topic for such a great course and a great time to be with you. But you need to know about federal sentencing guidelines, and I've included in your blackboard, is because that's where compliant agreements, terms, and conditions come from. That's where the federal government gets its notions for those sentencing periods that we covered, for the fines that we covered. Those are all mentioned in the federal sentence guideline manuals. Now I've got some final thoughts, and I think I'm going to put the thing back on the picture. As I thought about what I ought to share with you in our final get-together, I'd like to encourage you to be intentional in 2 things. Number 1, in mastering and then staying current with FDA laws and rules. And as I mentioned earlier in this session, you can do that yourself, but you can get immense help from the web, and you can get a lot of help from your industry organizations. They spend tons of money with lobbyists who get all kinds of reports, and the lobbyists in the industry watch the FDA like a hawk. So, and so much of what the FDA is public. So master it and stay current. A second final thought is for you to personally champion your own personal and your own company world-class FDA compliance strategies and guidelines. You know why? If you've got superb compliance strategies plus good guidelines, that'll keep you out of a whole lot of problems. Then you won't have to be worrying about fines and penalties. And then as a brother to that second point, you would do well to set quality, compliance, and honesty as top personal and corporate priorities and standards. Now I want to turn the camera back to me because I'd like to take a point of personal privilege and to thank you. I want to thank you for how professional each of you has been in this course. I expect you are astonishingly brilliant, and I expect to hear several of you become CEOs. I expect some others of you to receive Nobel Prizes or other famous awards because you are so smart in what you do. It's been a joy for me to be with you for these 8 weeks. The time has flown by. I remember very well preparing for our very first lecture, and that was just 8 weeks ago. I'm grateful for your cooperation and your good humor. Please let me know how you're doing from time to time. Until then, I'll see you later. Goodbye.